first thing is, do we have anyone looking to make public comment?
I can check, but let me, shall I take roll?
Yeah.
Sure, why don't you go ahead and do that?
Bashan,
Here.
Brynelson,
Here.
Falmouth? I thought I saw Julie
Oh,
Falmouth.
and I'm sorry to interject, but I just received a text message from Dave Rubin saying that he's on, and it's saying that the webinar will begin soon.
Well, I just started it,
Okay.
but I'm wondering why he's not. Let me find him.
No, I think he must have logged in through the wrong.
Right, I'll promote him to a panelist. On the same thing with Elizabeth.
There you go.
Great. Great. So. Okay, so it was at Falmouth. I thought I saw Julie. Okay. Fleischman,
Here.
Hamilton,
Present.
Judge Harper,
Here.
Hartston,
Here.
Kirkmeyer,
Here.
McRae,
Here.
Olvera,
Here.
Justice Petru,
Here.
Robinson,
Here.
Judge Rubin,
Here.
Shining,
Here.
Sarouche,
Here.
Spiro,
Here.
Torres Ambris, Judge Wiley,
Present.
Judge Yu.
Present. Thank you.
Okay, and I think I see Julie Falmouth.
Right. I'm here. Thank you.
Great.
Okay.
All right.
Well,
Thank
that is great. I'm trying to see on my screen, are there attendees? Because it says 3, but I don't see any names on my screen.
We have some attendees. I can call. Would you like me to call for public comment now?
Yes, please.
Okay, if any of the attendees are interested in making comment, please use the hand raising function in Zoom to indicate your interest. Give that a moment.
And we'll
I
check
don't
again a little
see any
later.
I don't see any raised hands.
Okay, we'll check again at some interim point. So we have first, to get done, a couple of sets of minutes. One is from October of 2020, which predates my time with the group, along with a number of people who are currently on. So Lee, if I could ask you to kind of take it away with the minutes.
Yeah, and actually Linda will handle that. Do you,
Right.
Justice Petru, want to do separate votes then? One for October and
Yeah, we have to, because I think we have too many, everyone who, I mean, all the new members who just joined in, for me, the end of November or December, of course, would have to abstain and can't vote on the October minutes.
Okay. So Linda, you want to start with October? You're on mute, Linda.
Okay, so do we have a motion for the October minutes?
I move approval of the October minutes. It's Dana McCray.
Okay,
Second.
and who's second?
Sharon Bashan.
I'm sorry. Oh, okay. Hold on. Sorry. And so for the vote, Bashan,
He seconded, so.
okay. I think we're supposed to still take a vote, people's votes. Brynelson,
Approve.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
and Judge Harper, I'm assuming you will abstain.
Abstain, yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Approve.
Justice Petru,
Abstaining.
Robinson,
Yes.
Judge Rubin,
Abstain.
Shining,
Yes.
Shining, okay. Sarush,
Yes.
Spyro, Spyro,
Sorry, I was muted. I'm sorry, I have to abstain. I haven't seen the minutes.
okay. Torres Embrice is absent. Judge Wiley,
Abstain?
Judge Yu,
Yes.
the motion carries. And then a motion for the December minutes.
I move approval of the December minutes. It's Dana again.
Okay. And a
Second, this is Paribas.
Okay. Bashan,
Yes.
Brynelson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Judge Harper,
Yes.
Hardston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Justice Petru,
Yes.
Judge Rubin,
Yes.
Shining,
Abstain, I was not present.
Sarush,
Yes.
Spyro,
I'll abstain.
Judge Wiley,
Same.
Judge Yu.
Yes. Thank you.
Thank you.
Okay, great. And that's it for the minutes, correct?
Yes, that's it.
All right.
Thank you.
So then I think we were going to take the regulation group first. Is that correct?
Yes. And is there PowerPoint up here, Linda? All right. So Ines and Fariba.
Okay. All right. Hi, everybody. So I believe we're going to start with the MCLEs, our recommendation. We discussed it last time. So we are modeling this after specialization or attorneys who are certified specialists. That's the number of units that they're required to have every 3 years. Because we are sort of creating this model where we're requiring paraprofessional, those who want to become licensed paraprofessionals under this new program, to pick a specialization. And so that's where we came up with these, the total number of units, and then it's sort of divided in a similar fashion into subspecialties. I remember at the last meeting, there was a question about why require trauma-informed training, a unit for that, when we don't require it for attorneys. And we were sort of at the end of our meeting, and I have been thinking about this because my position has been, in various discussions, that, from a policy perspective, we shouldn't really require more from paraprofessionals than we do from attorneys when they're doing similar work. For this one, first of its best practice, I do believe that at some point it should become a specialization unit for all attorneys, kind of like the legal ethics or competence issues and elimination of bias. And just because we're not requiring it from attorneys right now shouldn't stop us from requiring it from these new group of licensed legal professionals. Also, I think that when we compare it to malpractice insurance, for example, where right now we're not requiring it for attorneys, and I'm of the position we shouldn't be requiring it from paraprofessionals either. But I think there are different interests at stake here, and that is, malpractice really protects the service provider, and their assets will be protected against a claim, right? Here we're looking at something different. What's at risk is the risk to families and children that are involved in the case that a paraprofessional may be handling. And that paraprofessional should be trained to understand the role that the trauma that a client may have experienced in their lives impacts how the paraprofessionals should be delivering their services to be effective. So to me, that is enough justification to require it. And I hope that those people who are listening have some power to make changes to what attorneys have to take, that they do sometime in the future also make that change.
Reba, I see that Julie has her hand up. Do you want to take questions?
Yeah, I'm done. So we can open it to discussion. Yeah?
Julie?
Is that good?
Yeah.
All right. So Julia.
Thank you. I just continue to have objections to the overall number of hours for paraprofessionals in as much as they exceed the number of hours for attorneys. Attorneys can practice in any area. They're not restricted to any particular area of practice like paraprofessionals are. Attorneys can do MCLE in any area. They're not required to take MCLE in their area of specialty. And they're only required to do 25 hours every 3 years. Now, I agree that that's an inadequate CLE requirement, but I see no reason to impose a higher one on paraprofessionals. They are already specialists, and they have to take the vast majority of their CLE hours in their area of specialty. So I see no reason why we should pile on additional burdens onto these folks. Thank you.
And if I could talk on the regulation subcommittee too. Good afternoon, everyone. I do think a little bit of background here is important. The CLE requirements, I think, are a really important part of the regulations of a proposed paraprofessional, because this is the idea is there is going to be license requirements to become licensed, and then this is the requirements to stay licensed forever. And there is no law school. It is going to be specialized. So we did take a look at attorney requirements. So attorney requirements in California are 25 hours every 3 years. So that's roughly 8 1/3 hours per year. We also looked at some of the paraprofessional requirements in other jurisdictions. Arizona, for example, has 15 hours per year for their paraprofessional program. We thought that was a little bit high. We did consider going straight with the attorney requirement of 25 hours per year. I'm sorry, 24 hours per every 3 years. But when we looked at the specialization CLE requirements for attorneys in California, we thought that was the best model to model this after. So paraprofessionals are going to be specialists. That's exactly right. But they have not gone to law school. So it's the licensure requirements and the CLE requirements that are the training that protect the public and that ensure competent services. So we thought the 36 hours every 3 years, which models California attorney specialists, was the best model to go by. But again, I think this working group can propose something either increasing that or decreasing that. As far as the breakdown of hours, the 4 hours on legal ethics, 1 hour on competence, 1 hour on elimination of bias, and limitations on how much can be self-study, that also tracks the attorney requirements.
I comment, this is Judge Harper, on the 12 and a half hours of self-study. I believe, and I could be wrong, I think that's because it's 25 hours of requirements for the 3 years. They did half a self-study. So I would, if we're going to do 36 hours, I think that should move up to 18 hours to do half. I think that's where that number came from.
Ira?
Yeah, I have a question for anybody on this subcommittee. The MCLE requirements for specialists, lawyers who are specialists, are they required to have 30 hours in their specialty like this proposal here?
That's maybe a question for Greg. We did check into that. I just don't remember right now.
I think what we did was we basically tried to track the requirements of lawyers for all the designated hours. So the legal ethics, competence, and elimination of bias, and then just decided everything else should be in this area of specialty. Of course, people can do more training in other areas if they want to, but we just decided since the practice is going to be focused, the remaining of the CLA should be focused as well.
Well, in other words, we don't know the answer to my question, right?
No, I think that what I don't want to say what you said, I'm just repeating it, is that paraprofessionals, the way we are creating this program, we're gonna require them to pick a specialty. We don't require that of attorneys. So right off the bat, they're specialists. Attorneys have to become specialists, taking another test, meeting other requirements. But once they're specialists, these requirements, I believe, match what attorneys have to do. Am I correct?
I'm looking it up now.
Okay.
So
I'm a certified specialist, and it is my understanding that I'm required to take those hours within my area
Okay.
of expertise, and it has to be certified for that area.
Okay. Thank you, Steve. Does that answer your question, Ira?
Well, almost. I'm
Okay.
looking it up myself too. In other words, Steve said it's his understanding, but
Should we get back to you later, or do you want to?
I'll find it while we're online. I think Leah will.
yeah,
probably,
I think we could move on. I look for, there's a broken link I found on the State Bar website. So it's a little.
Okay.
not
All
right.
right. Any other, I don't see any other hands. Let me see. Anybody else have any questions or comments regarding CLE requirements?
Judge Yu has her hand up.
Judge Yu.
Oh, sorry. I thought we were going to move on to financial responsibility. That's where my question lies.
We can, if no one has any questions. All right.
Yeah, I can address financial responsibility. So, but let's not use this slide because I don't think this slide reflects our recommendations. Maybe you could move on to the next slide. So we spent a lot of time in the regulation committee talking about financial responsibility. And here's why. I think my perspective is if we are going to be creating a new licensed professional, it's essential that we have consumer protections. And one main consumer protections is ensuring financial responsibility. That is one of the important key recommendations from the ADLS committee or task force, that we consider a bond or malpractice insurance and a client security fund. It's also very common for licensed professionals in California to have a bond requirement for financial responsibility. If something goes wrong, there is a justice system, there's a court process, there might be insurance, but all of that is meaningless if the professional does not have any financial ability to pay a judgment or to address damages. So I think it's a basic requirement. We did spend a lot of time because it's not required of attorneys. So this is going to be part of the discussion of should we be requiring it of paraprofessionals if it's not required of attorneys. But as I said, I think it's important just if we're creating a new licensed professional in California to provide some form of financial responsibility. So bond is where we ended up with a joint requirement, a joint recommendation that we can talk through a bit. If you can go to the next slide of let's talk about bonds first. But in addition to bonds, we also talked about the possibility of mandating malpractice insurance. We did not reach an agreement on that. And a client security fund. So there is a client security fund for attorneys that just covers intentional acts like theft, not malpractice. And so we did talk about having a client security fund for paraprofessionals that parallels what exists for attorneys. And I'll talk about that as well. But let's start first with a bond requirement, because we did reach after a lot of hearing from a lot of different people, understanding more about what bonds are, what they are not, how big of a burden it is, what the expected cost is, if it would be burdensome to paraprofessionals or create too high of a bar for entering the profession. So we've talked about a lot of that in committee, happy to share that with you. But what we found is that a bond requirement is a relatively low cost way to provide for financial responsibility. Now, it does depend on what the bond amount is. And on the screen, there's some example, I'm calling these legal services like licensed professionals. There's a lot of other licensed professionals in California that also have a bond requirement, and they're often on the $10,000, $15,000, $25,000 range. So I don't mean to suggest that this list is representative of all bonds in California, but these are For immigration consultant is the one I think we talked about the most. And LDAs as well. What we found was that the bonds would protect the public pretty significantly in terms of negligence or intentional acts. It's not claims made. So in other words, it's not going to expire on you. It doesn't matter when the claim was made. It matters when the bond was in effect and when the services happened. So there's not this kind of insurance issues or exclusions, and they're relatively inexpensive. So for a bond of $100,000, which is what we're proposing, it's about 1 to 3%. So something like $1,000 to $3,000 is typical. The cost could go up depending on credit. With this type of bond, it's likely going to require a credit check, as well as, of course, if there's any license history like discipline or things like that. We did look at other jurisdictions. The Washington State paraprofessional program actually had mandatory insurance, and we did not reach consensus on that. I do want to take that up separately, but our proposal on a bond is twofold. One is we recommend that a bond be required for a paraprofessional to have a license and maintain the license. And the other is with respect to the bond amount, which I assume there'll be some discussion of, but our recommendation is $100,000. Fariba, did I cover that?
Yes, and I just want to say that with regards to the even requiring and to the amount is that I read the bill in support of increasing immigrant consultant bond from 50,000 to 100,000. I think it was done in 2011, if I'm remembering correctly. And it really speaks a lot to why. And that's because of the vulnerability of the population that will be using these services, just like vulnerability of the population that uses immigrant consultant. The only difference I see is the majority of the folks that use immigration consultants are non-English speaking, monolingual, and they're even more vulnerable. So if you read the code section, they're very, very protective, and deservedly so. And I just want to say that for the population that be using paraprofessional services, I believe they're as vulnerable. My specialty, of course, is family law. And I can tell you, nobody comes to family court when they're happy. They're always in trauma. Something is happening, something urgent, and they're really open to being taken advantage of. So we have to the extent we can, we really need to make sure we provide consumer protection. So that's why I am supporting at least the bond and in the amount of 100,000, similar to immigration consultants.
And one other point before we open it up for discussion, I do want to make clear that this is not a per claim amount. This is a total liability that the surety would be on the hook for. So, if there's any claims, it reduces the amount that's left on the bond. So it's not, I think one thing that we considered is, should we, should it be $25,000 if most of the claims might be limited to $25,000. And the idea is this could be a multi-year bond, and it's not a per claim amount.
So, we have Judge Yu, Judge Rubin. So let's start off, Judge Yu. And Ira, I don't know if your hand is still up from before or.
Oh, sorry, I'll put it down.
Okay, go ahead, Judge Yu.
Thank you so much. And I think, Amos, you answered one of my questions, because I was wondering, is it a per claim or is it per year? So if a person were to receive more than one claim in a year, that 100,000 is going to extinguish and go against all the claims that come in that year.
That's correct. And usually they're multi-year. I mean, I think we could regulate if we wanted to have year bonds, but I think it's common to have 2 or 3 or 4 year bonds. So we'd have to deal with that as well.
So the 100,000 would be for all claims entered in a 3 or 4 year period.
That's right. Unless as part of the licensure requirements, we require them to have a certain amount when we check on them. In order to maintain your license, you need to have a bond amount of a certain amount. We could do that, but right now, the bond is just a contract, and that if you have $100,000 bond, that's the maximum the surety is responsible for.
My other question was whether or not your working group thought about having a different amount of bond for different practice areas, because for people who are handling unlawful detainers, now that I know that it's a one amount for a certain period of time, I'm not sure I feel this way, but I would think if you're handling an eviction case, having a $100,000 bond might be a lot more burdensome and maybe not as necessary as if you were handling a family law case. But knowing what I've heard now, I'm not sure I'm still at that point, but thank you.
I also wanted to just clarify that, and Amos, please correct me if I'm wrong. If a claim is made against 100,000 and recover and is paid out, I believe that in the immigration consultant area, if the person falls below 100,000, they can't practice, right, Amos? Because if it's a 2-year bond, they can't practice until it expires, the 2-year expires, and they're able to replenish. Is that correct? Or do they have to actually run out of money?
So I'm not sure how it works in immigration, but I do think it's an issue for us to consider if we want to have some requirements. The bond itself is public, but not necessarily what claims were made on it and how much is left. So, we could have a requirement that there needs to be a certain amount, a certain bond amount initially, and in order to renew a license or continue a license to have a certain amount outstanding.
That's right. That's right. So we want the group to consider that. Do we want a minimum amount in the 2-year and then maximum of, for example, 100,000, but not below 50,000, for example?
And I know Judge Rubin has his hand up. Remind me if I'm correct that the premium levels are about 2 to 3% of the bond amount. Is that right? At the level we're talking about, at about 100,000, just to have some context.
That's right. I think we heard from some people about this, but we're not experts. I think my understanding is at a $25,000 bond amount or less, they're pretty cheap and relatively easier to get. I don't think they're usually required credit checks and things like that. When it's above that, and certainly at the $100,000 level, if there's credit concerns or financial concerns, or there are problems with prior disciplinary, the cost, of course, would be expected to go up. But the standard policy would be, I think, 2 to 3%.
Yeah. So looking at my notes, cost of $100,000 bond for immigration consultants run between $1,200, $1,700 for 2 years.
Okay, Judge Rubin.
Caught me. First of all, Happy New Year, everybody. Although given the first 6 days, here's a 2022. Anyway, I guess I have a question, and because I'm sort of late to the party, if you will, I'm sure a lot of this was discussed, and I just need a little grounding in this. My general thought is, when I'm looking at the financial piece, for instance, is that to the extent that we deviate from what's required of attorneys, someone could easily look at what we're doing as having kind of a penal quality to it. Some of it we can justify easily, like an attorney has, for instance, on the education side, the MCLE side, well, an attorney has several years of law school, and after that, she may have, clerk, whatever, she has a more robust grounding in the law, and so more expanded MCLE is a way that we sort of can help compensate for that and protect the consumer. When we get to these bonds, it seems one of the reasons we don't require, I guess, attorneys to carry malpractice insurance is because, and this is where I need help, is it sounds like there is like an unspoken premise that we believe that attorneys are in the main going to have more, they're not going to be judgment proof in the main. They're going to have more assets to go after if you are a litigant who's had a bad experience. And it seems like that's my sense of it, of what was happening. And it seems like to the extent that we are asking or suggesting having bonds or what have you, our impression collectively is that people who go into, sorry, unpopular, all of a sudden, that people who go into being paraprofessionals will be less capitalized, if you will, if something were to go wrong. Is that if I was even, it may have been a little bit crude, but did I kind of capture the basic thinking of it? And if so, do we know that to be the case?
So I'll give my thoughts on it, but I definitely think the group should discuss it because we did spend a lot of time, and I think Fariba could speak to this even more because we spent a lot of time, I think, from the position, why require it for paraprofessionals if it's not required for attorneys? I don't know so much about the background of why malpractice insurance is not required for attorneys, so that's why I have to defer a little bit on your question. We did hear from some people who believe strongly it should be required for attorneys, malpractice insurance. The reasons that I heard in our subcommittees were not based on the assumptions you're talking about, Judge Rubin. I think where we focused on, again, separate from the malpractice discussion for attorneys, I am focused on consumer protection. So our working group, this working group, has a dual goals. It's not just creating the licensed professional, but it's protecting the public. And again, a bond requirement is something that is pretty common for licensed professionals. So attorneys are the exception. But again, there may be many reasons why attorneys who self-regulate in many ways don't have a malpractice insurance. But if we are creating a licensed professional, I think the main purpose of a bond requirement would be financial responsibility and consumer protection, and do it in a way that doesn't create too high of a burden. And this is something we need to all consider, what the burden is on entry into the profession, because we don't want to make it too high. But I think for licensed professionals, a bond requirement is something that's pretty common and they're pretty readily available. And again, other states like Washington did require malpractice insurance for professionals. So I don't know if that answers your question.
Well, yes and no. Right. I understand all of that. And the reason they need that the public would require of a paraprofessional some kind of bonding is because we don't think they would otherwise have capitalization to cover a claim.
That's not the only reason. I think the idea is that it's, and certainly with respect to the bond versus malpractice insurance, even the ease with which a client, a harmed client, can actually recover is enhanced by having these coverages, right? Because otherwise you have to file a lawsuit and go to court. And the bond in particular, from what we heard on the subcommittee, it is a more accessible remedy for a client, an injured client, which does not require the filing of a lawsuit.
And for me, I think the key point is we're creating a brand new program, right? Why not approach it from a best practice standard, having learned what we have learned, knowing what we know? Perhaps when the attorney program was set up, whenever it was set up, we didn't know what we know now. We know better. And put that together with the reasoning that Amos and Leo mentioned. That's why I think it makes sense to have a bond, $1,200 to $1,700 every 2 years, relatively reasonable. And it's required from similar professionals, such as immigration consultant, who may be dealing with sort of similar population.
I can also add briefly that we went through the malpractice insurance as a possibility and a restitution fund as a possibility before coming back and agreeing on the bond as the best alternative. So that might also inform some of this discussion.
Leah, you're muted.
Stephen Fleischman.
Yeah, I was just going to say, Judge Rubin, I'd encourage you to take a look at the State Bar's last report on mandating malpractice insurance. I circulated a link to it before the last meeting. You know, my take on it is the State Bar has been looking at this issue for 40 or 50 years, multiple times, and has never come to the conclusion that malpractice insurance should be mandated for attorneys. My personal take is borrowing from these other professions like legal document assistants and immigrant consultants, the bond requirement is a better way to go. And if somebody wants to purchase malpractice insurance on top of that or in lieu of, that's fine. But mandating malpractice insurance, I think, would be a mistake.
Ira, is your hand up now for this item? Okay, Ira and
Yeah.
then Julie.
It is. I'm looking at one of the, I think Steve Fleischman's gave us a link to 2 reports. Anyway, I'm looking at one of them right now. It's a report from March of 2019 by the working group on whether or not to require malpractice insurance. And I see here, this is addressing, well, anyway, I see here that it says a principal argument in favor of legal malpractice requirement is that of public protection, noting that clients who are harmed by attorneys' malpractice generally have little recourse, et cetera, et cetera. Even if they are successful, the likelihood of recovering a substantial settlement or judgment is low. So I don't know that there is, it looks to me like the idea that attorneys would have more assets, would be more recoverable and less judgment proof is not the case.
I think, at least from my perspective, I don't know how other people feel, but I think it's great that we're looking at other way other people do it to inform our decision. I just want to make sure that I can understand why we are deviating from our own, from what lawyers do. But I think Ms. Sarouche sort of got me to a place where it makes sense. And the way I'm formulated in my head is, the likelihood is that people who are going to be seeking out the assistance of a paraprofessional are people who have less money to begin with. And the barrier to entry to a lawsuit to recover money would be more difficult for them than it would for someone who can afford a lawyer. And so bond would be a compromise for that. I mean, that moving against a bond is easier. It's going to take less money. The person who has more limited resources would give them something, and the bond is not going to, in some cases, cover the loss, but it's a compromise place. So that makes, I can live with that.
So we've got Julie and then Kim.
Thank you. Steve Fleischman is correct, and so is Ira, in that the bar recently created a working group, one of many, to look at this issue of whether malpractice insurance should be required of attorneys. And I believe Linda staffed this committee, and I don't want to put her on the spot, but she may have more information than any of us do about why they reached the conclusion that they did, that they basically have no conclusion. Probably part of their reasoning is that attorneys contribute to the client security fund. And it's not very much. Correct me if I'm wrong, somebody, but I think it's $40 a year.
That's right.
And the client security fund I've read is in trouble. There's been a lot of payouts. There's been a lot of attention paid to whether that contribution should be increased. I gathered from the regulation subcommittee's memo that they're not recommending that paraprofessionals contribute to either the attorney's client security fund or one for just paraprofessionals. The limit on CSF, though, as is pointed out, is that the CSF only pays out for intentional torts like theft and intentional dishonesty on the part of attorneys. It doesn't cover negligence, which is why the bar has looked so many times at whether malpractice insurance should be required of attorneys, because that does cover negligence. And it's really hard to prove intentional torts. So that's another, just some background information on why we don't, the attorneys have preferred to go the CSF route as opposed to malpractice insurance or bond.
So Linda, do you want to speak briefly to your favorite group And then I think Amos will want to jump in and clarify the recommendation around the restitution fund for the paraprofessionals. But go ahead, Linda.
So ultimately, the malpractice insurance working group concluded that there wasn't enough evidence of harm. So it was hard to find proof that there are people who are harmed by malpractice who are unable to get any meaningful recovery. The problem with that is that it's kind of a chicken and egg thing. If an attorney does not have malpractice insurance, they can't, the victim of that malpractice can't find an attorney to file a lawsuit against an uninsured attorney. And so it's trying to find these claims that just don't exist. It's like proving a negative. And so their conclusion was we need to do more research, but we were kind of at a loss in the end of how to try to find these claims that were not pursued.
Kim, why don't we go?
That's the essence of it.
We have a number of people with their hands up. So I don't know, Amos and Frida, should I keep going with that for right now? Okay, Kim.
Yeah.
So this is an interesting one from my perspective, because this, amongst our boards and bureaus, nobody that I know of, and I'd have to poll them, but requires a malpractice insurance, including our physicians. They aren't required to have malpractice insurance. There's one exception if they're in one type of setting working, but other than that, they aren't. But it's for this group that we're talking about, there is almost a need for something, because the group, you know, anybody's going to be able to use these paraprofessionals, but we're really looking at a group that couldn't afford to go out if they did have something wrong. Then they're going to have to file something against these individuals. And so it seems like because of the group that we're trying to target to assist, you need to have something. And I'm not sure how all of the bonds work. And I wasn't on that, your subcommittee. And I know from experience with some of our boards how the bonds work. But if they don't have to do a lot of work to get those bonds, I think we need to have something to protect these individuals. So I'm opposed to making have them have malpractice insurance, but it does seem like we need to have something. So I am kind of supportive actually of the bonds.
Okay, Stephen Fleischman, and then Sharon.
I just forgot to add that professional liability malpractice and insurance policies almost always are burning limit policies, which means the amount spent defending against a malpractice claim comes out of the $100,000 coverage. What that means, and also those policies typically have a client consent requirement. That means the paraprofessional is going to have to agree to the settlement. If the goal is to maximize recovery for the consumer, the bond may be the better way to go. In addition to all the other reasons we've talked about.
Sharon. I can't hear Sharon. Can others?
No.
She's on mute. Sharon, you're on mute.
I hate when that. Sorry. I was going to.
Zoomitis.
Sorry. I was going to make the exact same point that Kimberly made, that we have to have something in place to make sure that clients can recover, especially in situations where it's not an intentional tort, but it's negligence. And I also agree with you, Fariba, that we should come at this from a best practices standpoint and not mirror it after an attorney system that clearly has some issues.
Okay. Amos, do you want to continue on with the?
Yeah, so, and I think I can be brief on malpractice insurance because that was discussed quite a bit already. I think as people commented, it's not required for attorneys. There has been a lot of thought about whether that should change or not. we did not come up with a recommendation to require malpractice insurance. I do think malpractice insurance could provide increased protection. So for example, those are usually per claim limits. So if there was 100,000, 300,000 policy, that would be 100,000 per claim. And it provides protection to the paraprofessional. They would get a defense and et cetera, et cetera. But we did not come up with a restriction. One other point I want to say about malpractice insurance, because we did look around, and even though malpractice insurance is not generally required for attorneys in California, when the court gets involved and appoints an attorney, or there's an attorney panel, or there's a referral service, those often require malpractice insurance. So, and in family law, when, minors counsel and probate, in criminal matters, when the court has a program that's appointing attorneys, malpractice insurance is required. And so this is going to be, I think, a creation by the court and the bar through court rules mainly. So I don't think it's out of the question that we would require malpractice insurance, but I think our recommendation currently is at least it should be encouraged, and maybe there should be some disclosure about malpractice insurance, but we're not recommending. And by the way, we don't even know if it would be available and how much it would cost. And I think we were concerned about the barrier to entry. Malpractice insurance, we assume, would be more expensive than the bond. So anything else about malpractice? If anyone want to have questions about malpractice insurance?
I don't see any hands.
Okay, the final thing on financial responsibility that we did look into, and Julie, this might be a little bit different than what you were saying about the client security fund, but we do recommend that there be a client security fund similar to what attorneys have. Now that is limited to intentional conduct. As it was said, that is funded by a fee for paraprofessionals. And that is something that exists for attorneys. We don't see any reason not to have it. It doesn't sufficiently protect consumers, so there wouldn't be a need for a bond. As was already mentioned, it doesn't include negligence, malpractice claims. It's just not part of that fund. But it's not sufficient to be the only requirement, but we think there should be similar to attorneys. And one caveat is I think the CSF, the Client Security Fund for attorneys, it takes a really long time on average to get recovery from those claims because discipline is required as a precondition. So we also, I think, are of the opinion, I think it's part of our recommendations that we don't require discipline as a precondition to recovery. That's final discipline. There might be a complaint, but again, that's something we're sort of still working through. We also, I think, agreed that to the extent this committee or the bar does not agree to a $100,000 bond requirement and does not have malpractice insurance requirement, that it really is important to have something. So the other option we considered is to have a restitution fund. So basically the client security fund expanded to include negligence or malpractice claims. But in talking to people, the administrative costs would be high. The difficulty of administering it would be high. So we're hoping, and our recommendation is we don't do that unless we don't have an agreement about the bond requirement. So that's it on financial responsibility. Unless if people have questions, I can go on to the other recommendations.
You're muted, Leah.
All right, Steve Fleischman and then Julie.
Yeah, I'm in favor of the recommendation to have a client security fund. My only comment would be, I think it should be a separate fund segregated from the attorney fund. And number two, what I haven't seen in the recommendation from the committee are dues for paraprofessionals to pay. In my opinion, that's a easy one. You just link it to dues attorneys pay, which are set by the legislature every year. And you could just follow, if attorneys are paying, I think it's $40 a year into the CSF, you could do the same thing for paraprofessionals. I just, again, recommend that it be segregated.
Okay, Julie.
Sorry, Amos, I must have missed that. So I just want to make clear or get clarification. So your subcommittee is recommending both a $100,000 bond and payment by paraprofessionals into a CSF, either the attorney CSF or a separate CSF. I just didn't get that from your memo.
That is correct. Sorry if that
Okay.
was not clear.
Thank you. Thanks, and I apologize.
Okay, I don't see any other hands up.
Okay, so we can go into the other recommendations and maybe be a little quicker. Sorry about the time. We have other recommendations about regulations. They're included in our report on informed consent requirement. We have some draft language in Appendix A, a written agreement and mandatory disclosures requirement. That's also an exhibit in Attachment A, pages 2 to 3, and a scope of practice and prohibited acts. I do think we're going to talk through that a bit and maybe put the language up. Fariba, I just saw your email. Do you want me to cover informed consent?
That first one anyway.
Okay, so Linda, can you put the informed consent language up?
Yes.
So the idea here is, and again, this was a recommendation by ADL's task force as well, that there be potentially we consider an informed consent requirement. Remember, the idea here is that people are engaging a paraprofessional instead of a lawyer, and that be an informed choice is the idea. So we attack this in two different ways. One is to have a written agreement requirement with certain disclosures, and to separately have an informed consent requirement. And so this is what we drafted for the informed consent. The idea is that as part of, before providing services, it be explained to the client or prospective client that they're not a lawyer, what the fees would be, maybe available alternatives, you know, what the risks are, if there's any financial arrangements, so we're going to get into that separately, and what a reasonable estimate of the cost of services would be. I see this as a written document, a separate written document, but I don't know that we're tied to that. An informed consent could include a written, you know, best practices might be to have a separate writing to confirm there was informed consent. But the idea is that there just be informed consent to the engagement. And so if people have thoughts about this language, oh, by the way, on this, for informed consent and for the next documents we're going to look at, draft language, these are not final language. We weren't drafting the final rules. I think we are in the position where we're just trying to get the concepts down. And we're going to be looking through the rules and proposing final language or where they go. Are they disciplinary rules or are they rules of court? But this is just to have the basic idea of what we're thinking.
For the next one, which is written agreement and mandatory disclosures, we got help from Washington State's limited legal license technicians documents. And I'm not sure if we're going through paragraph by paragraph, if people have read these. Leah?
Well, you've got a couple hands up and I'm assuming it's on informed consent. Is
Yeah,
that right?
maybe what I recommend, can we just quickly do written agreement and mandatory disclosures? Because I think one of the important questions is, do we want both? Or is one of them sufficient? And the written agreement and mandatory disclosures, as Fariba mentioned, this is based pretty significantly on Washington State rule. It's APR 28G. So they have a written requirement. And in California, attorneys do have a written agreement requirement. It's part of the Business and Professions Code. So if we want to create it for paraprofessionals without, you know, that maybe that statute could be amended, but we could do it in terms of our rules of professional conduct as well. So the idea here for the written agreement and mandatory disclosures, you have the language in the report and on the screen. The idea is, again, clear and conspicuous disclosures. It's not an attorney. We recommend that it should be clear in writing what the paraprofessional can do and can't do. We aren't able to develop all that language right now because the practice groups are still figuring that out. But at some point, I think the writing should make it very clear what they can and can't do. You know, we also went through, you know, protect confidentiality, and those kinds of requirements, right
And
to
the-
terminate the contract,
Mhm.
and that they won't go beyond their scope of practice. So yeah, happy
So,
to
but
answer questions.
Let me ask a quick question. Does the committee have a recommendation at this point about whether to have both documents or one? Or is this truly like work in progress right now?
Work in progress.
Okay, so obviously I think we can go ahead and take some comments and questions, but I think we're gonna have to do it in relatively short order. I don't want the discipline committee to just simply not have time. And we're not done here. So I mean, I see that both Stephen, and I also need to double check to see if anyone, any of the attendees wish to make public comment, which we'll do between the two groups. But given that this is very much, it sounds like a work in progress, I suggest we not do a real drill down into the language of various paragraphs. But instead, if anyone has any general comments or concerns they want to raise.
Your Honor, if
Now-
I may just add that if you people look at the immigration consultant legislation, a lot of the specificity is also in that legislation, including font and size and color
Okay.
of the disclosures. Just letting you know.
Okay. So how about Stephen Fleischman?
Yeah, given your Honor's comments, I'll be quick. I continue to object about having referral fees as part of this program. Our committee was not given jurisdiction over the rules prohibiting attorneys from sharing fees with non-attorneys. In contrast, the Closing the Justice Gap group, which just had their first meeting yesterday, has been given specific charge of examining that rule and whether to allow attorneys to share fees with non-attorneys. I don't think our committee should take any position on that issue, because by doing so, we're forcing the hand of the other committee in addition to biting off a huge issue. And given your Honor's comments, I'll be quick, but if we're gonna go down that road, that's something that's gonna have to be debated and thought about very seriously. So I understand this is just language for now and we need to move on.
All right, thank you. Julianne or Julie?
Yes, thank you. I read this a little differently. On your informed consent language, the last word in the first paragraph is explain. So I thought that meant there would be an oral explanation, an oral discussion between the paraprofessional and the client as to what we're doing here and what the limitations on my ability to help you are. And then the written agreement would be a written agreement, obviously, that would be signed. So
That is a possibility to do it that way, yes.
okay. And I don't want to wordsmith in light of the justice's arguments, but I don't know what you're getting at on the informed consent language. I don't know what you're getting at in subsection C that's not already covered in subsection A or D. The risks of hiring, of agreeing to the PP. I just don't know why C is necessary. And also there's a bunch of stuff in here in a lot of these various documents which haven't been decided yet by either this working group or whoever. So I'm hoping you're open to deleting some of that stuff if that stuff gets changed.
That's why it's a draft.
Yeah,
Yeah.
exactly. Let me just jump in again. It's quite clear to me that that's why I asked the question, a work in progress. And so I can't imagine that anyone is being closed-minded about making modifications, deletions, additions, right? So just to piggyback on the last comments though, I'll throw in my 2 cents, which is my personal preference to have something written that gets signed off on, that there is a record of. No one ever knows what actually happens in a verbal discussion, and who's going to start telling people, or giving the guidance about what exactly needs to be said. It can be said, with a lack of clarity. Keeping my own comments short, I think it should be something written, whatever it is, that is signed, kept, kind of end of story. Ira, I see your hand up. Or not.
No, I was up. I just want to point out that regarding referral fees, the issue of referral fees given by, or fee sharing by a paraprofessional does not necessarily overlap or have anything to do with sharing fees between lawyers' fees with non-lawyers. The paraprofessional might have a fee sharing or referral fee arrangement with people who are not lawyers. And so I think it is within our purview.
I don't see any other hands.
So I think that's the end of the regulation subcommittee. We do have one more proposed language about scope of practice, authorized and prohibited acts. Those again come pretty straight from the Washington rule, 28F and 28H, as well as the Utah rule, as well as Fariba mentioned, the immigration consultants rule, to just have some general framework of what paraprofessionals do, in addition to what's going to be decided in practice areas specific. So, if people have comments, that's fine, but I'm also happy to defer to the discipline subcommittee.
Yeah, I think we should move on. I mean, I think it's very helpful to start having this, but it is going to be so informed by what gets discussed. Does anyone have anything they wish to say about the scope of practice draft document? I mean, my quick eyeball was that it, in general, it certainly looks appropriate, but we need to do a drill down. Okay. Linda, can we check to see whether there's anyone who wishes to make comment?
Sure. So if there are members of the public who wish to make comment, we can take public comment now. You can use the hand raising function in Zoom. And if you're on the phone, you can press *9 and that will show a raised hand. So we can give people a minute to do that. I don't see any raised hands.
All right, great. Then let's roll into the discipline committee.
Great. Kim.
Okay. Well, good afternoon, everyone, and Happy New Year. So the great thing actually about us getting moved over was we actually were able to have 2 other meetings between our last meeting and this one. So that was kind of nice that we actually got a time to discuss more items. But I think the best thing, and thank you, Linda, for putting that up. I think the best thing for us is just to go over the diagram that's on the last page of the document first, just so we can kind of lay out we've gone over this a little bit, but this really is the process that we've put together. I know there's been discussion about.
Sorry to interrupt, Linda. Is there some way to just make the one slide the screen rather than the one slide and next slide so that we can see it more clearly?
Oh, I'm not sure why that's not working. Let me try to do this, redo the share and see if I can make that work. Is that working now? Okay.
All right.
Not for me.
No?
Is it working for others?
Yeah.
Working.
It might just be my connection.
Yeah, it's working out. She was in presenters mode. She's into just single screen.
Oh, no, here we go. I got it. Let's go. Oh, that's better. Thank you.
So we've kind of gone back and forth. We've had several presentations from different groups from State Bar, which has been really helpful for us in making some decisions. But what we've kind of looked at is almost, again, a cross between using what's currently used at State Bar and then also using some new items, and thinking, of course, that we're going to have part of our kind of assumption is that we're going to have some type of a board that oversees these paraprofessionals. So with that in mind, if you look at the bottom line, this is actually, it goes from the bottom to the top. So if we receive a complaint in that whole complaint and investigation process, that would actually be done by OCTC within State Bar. So they'd be the ones that are doing that. If that complaint comes in, it gets investigated. If it gets closed, one thing we do want to have is the current process that is actually out there for State Bar right now is that the complainant may request a review, basically an appeal, and that would go to CRU. Leah, the name of the acronyms, I should have had those on here, but
it's CRU, the Complaint Review Unit.
Complaint Review Unit. So it would come in and it would go all the way up for that Supreme Court review if they actually have a complaint that has been dismissed and they aren't in agreement with it. If they do go up, it gets investigated, And if there is a violation that's identified, once at that one point, and this is kind of where our last few meetings have actually spent a lot of our time, is between the step of an investigation being completed and some violations being found, and then the next step over to filing a notice of disciplinary charges, is that middle ground. And that's where we're still having discussions to identify what exactly we want to recommend. But as you can see here in this slide, we're thinking there would be some type of potentially a diversion program. And what we're meaning by diversion program, I think, is that it's an individual that has a substance abuse or mental health issue. And what would that look like? And we're still discussing that term. The other thing that is different, and this is different from the state bar, is that we are recommending potentially a citation and fine program. So this would be for a minor type of violation with the individual that comes in, and it's not anything that, you know, they need to have their license taken away, or they need to go on probation or go into the ADP program or anything like that. But it would be an individual who just lower level violation. So we would issue a citation and a fine, and we're talking about potentially some type of order of abatement depending on what type of violation that it is. The other thing is we're looking at is an agreement in lieu of discipline. That's something that is still currently in discussion, but that would be an outcome where the individual has some type of violation. It does actually go to the level of, it would be a lower level, almost disciplinary action, but we believe that they would have some type of education or some other type of rehabilitation to where they would not need to have discipline. And if they agreed to that, then that proposal, that would be the end of it. And then the next step is if that none of those fit, then it would actually be to where we are going to file charges, or if there, at that point, if there is a licensee that stipulates to all of the findings, then we would go through to a stipulated decision, and that would go up through the process into a settlement, into a final agreement. If we do file charges and that notice of disciplinary charges, then that goes up and it would go through the settlement conference. So there'd be a staff adjudicator to manage that settlement conference, and it would be set upon mutual agreement between them. And if there isn't an agreement that can be reached, then that's where we're recommending a hearing with a 3-person hearing panel. So this is where it differs from the normal process. That it would be a 3-person panel. You'd have that staff adjudicator on it, a paraprofessional, and a public member. And this panel would be one that's trained, that knows the process. They would hear that decision, and then they would provide that decision. That decision would actually go out, and if it was a license suspension or revocation, that would be reviewed all the way up to the Supreme Court. They would give their final blessing. And then we also have, if it is if it's actually appealed by any party, then it jumps into that next line. And also any type of settlement that comes out of the agreement, what our recommendation is those approvals, and actually even the hearing one, I don't think it shows it quite right in this chart, but either of those 2 types of decisions would be reviewed by this paraprofessional licensing board to agree with the decision, or to basically, if they don't agree, then it would go to the hearing, the next option of appeal. So that's where we're really looking for the work group to provide us some input on this. So we already have a hearing panel. So at the next level, should that appeal be done by the paraprofessional licensing board, or should it basically go to that another 3? It would be a different one because we'd have a couple. Do a different 3-person hearing panel made up of a staff adjudicator, a paraprofessional, and a public member. And again, even that outcome of that appeal is going to go up to the Supreme Court for that final sign off. So that's kind of the process that we have right now. Again, that mixed bag of kind of what we're looking at as far as the process. And that's kind of a quick overview of it, but that's kind of where we are right now. I know last time, actually it was the time before, we had talked a little bit about unlicensed complaints and what we're doing with those. We have had a presentation on that. We're still talking about that. We kind of moved from talking about that to a few other items in our last meetings, but that's something that we're still going to talk about as well. So I don't know if Leah, if you want me to stop there before I go on, or Justice Petru.
Yeah, I was just going to say, because we do have a couple of hands and I don't know if they're responsive to the questions that you pose. So let's check in with folks. Amos?
Yeah, so thank you. This is great work. Thank you for all you're doing on this. One of my questions is about, you mentioned you're considering an order of abatement. Would that be restitution? So in other words, is part of discipline potentially a restitution order for, the client? I think that might be something that could be considered. And I think if that is going to be allowed, I think you'd have to think about, where does that get appealed? Is that something that also would need to go all the way up to the Supreme Court?
When we were talking about our orders of abatement, we didn't bring in actually restitution as it, and I'll look to my other partners, Julie and Ira and Sharon, that we were thinking of in terms of an order of abatement at that level, because again, at this one, it would probably be a very lower level type of violation. But if it was something, and I'm just giving from my example of with the medical board, with them, it would be like if the physician didn't turn over medical records, part of the citation would be that as that order of abatement is that you give the patient their medical records. So that is a complete closure then of that case. In the legal world, I'm not sure if there would be a lot of orders of abatements needed as to that process, but just in my thinking for restitution, that sometimes comes up when they go through process all the way up to where you're looking at disciplinary action. Some of that sometimes is restitution for individuals, but we actually have not talked about restitution for a client yet. Julie, anything to add, or Ira?
Yeah, I just want to add that this whole citation and fine program idea is based on Business and Professions Code section 125.9, which applies to the Department of Consumer Affairs boards. And it's been around for probably 20 years. And to my knowledge, and I agree with Kim, restitution is not contemplated by that statute. The statute encompasses a citation, which is like a ticket that says you violated this law, stop it. And the order of abatement is stop it. And there can be a fine up to $5,000 per violation. So that's what we're basing it on, is 125.9 of the BNP code.
Anyway.
Just Petru, did you want to call on Stephen?
Yeah, why don't we go ahead and do that, Stephen?
Yeah, thank you for all your work on this, but I have a more sort of fundamental question, which is, why aren't we just adopting the existing disciplinary system that's already in place? I personally would consider the paraprofessional program a huge success if in 5 years we had 500 people signed up and in the program doing it. Now, how many complaints are going to come out of a program that size, and does it justify creating this entirely separate program as opposed to simply folding it into the existing program? Now, if in 5 years or 10 years, there are thousands and thousands of paraprofessionals and all these complaints are being generated, then yeah, maybe a system like this makes sense. But I mean, staff should be able to tell us for every 1,000 attorneys, how many complaints with the state bar are initiated this year. And, at some point, we're just creating a new system that may not warrant the size of this program. How do you guys respond to that?
Well, we were given a presentation by staff that informed us of the cost when you utilize the State Bar Court, the hearing panel and the review panel of the State Bar Court. And that dramatically increases the cost for both the bar and the respondent. And so we were trying to utilize the state bar's existing complaint processing and investigation systems through the Office of Chief Trial Counsel, where that makes sense, and then replace the state bar court, which is enormously costly, with a different kind of decision-making process. So that's why we came up with these panels, and possibly the use of the paraprofessional board, depending on what that board ends up looking like at the end of this process.
But in terms of the cost, this has got to cost more on some level than using the existing system. And so in the first 5 years, if there's a total of 10 complaints filed against paraprofessionals, how much is this going to cost versus the state bar program? In other words, what's the need to start with this huge complex program as opposed to just adopting what's already in place and seeing where it goes?
If I may reply to that, I won't be the only one, I don't think, but it's not, it does not necessarily cost more. In fact, it costs less. And that's what Julie was just saying. The state bar, understand this is not an entirely new program. The first line on the bottom, I'll call that the first line on the bottom, is using the state bar's current staff and processes. The second line, the next line above that, is using the state bar's staff, and if there are any changes in the processes, they're not going to be anything complicated. The one place where it does significantly differ from the state bar's processes is the next two lines, which in the state bar system are done by the state bar court. And as far as expense, like Julie said, the staff at the state bar told us that, that it adds a great deal of expense to use the state bar court. And even though the state bar court is already there, a percentage of their cost would be allocated to the paraprofessional program. This substitute program, which is just in the appeals, as you can see, those two green lines, uses only either one or two panels of hearing officers, and those are the same. They're appointed. They will be appointed for a period of a year or two, and they're not. So the expense is not great. It's and they may have nothing to do. If they probably won't in the first year because they're governing appeals only. Okay, that's it.
And just one thing to add on too is, because these are individuals who are paraprofessionals, the other thing is we did want part of the review process to be by a paraprofessional, not solely by attorneys, which if it went through the state bar process, it would be solely by attorneys. And so the other thought is that they would be being looked at by, to some degree, a set of their peers as well.
Okay, Carolyn?
Okay, thank you. Yeah, thank you for this very clear, the chart is really clear, so I really appreciate it. I must admit, I haven't had a chance to review all the proposals, having missed last December. But I guess my questions sort of echo along Steve's. I get two parts of questions, but the first one is not related to Steve's, the diversion. I like that idea, and I think that's a great concept, and there's the lawyer's assistance program that I think it might be spinning off of the state bar. I'm not sure, I haven't really followed. It might be getting in its own world, but that's something maybe that could be rolled into that. I don't know if you've thought of that. And I don't know what phase you're putting that at. It seems you won't know if someone needs diversion until you issue a citation or discipline, and then they respond to that. So, and I'm also concerned about why more elements, and maybe you have maybe more elements of the way the state bar disciplinary system can be wrapped into this. But my bigger question is, are these administrative law judges, and has anybody studied the impact on what that means for due process, and B, the timing and cost of delays of appeals challenging the due process nature of this proceeding, because it does impact rights. And so I'm not an expert in this by a lot, but it hits me if the staff adjudicator is not a judge, if a public member is not a judge, and they're appealing people's rights. Isn't that, did anybody take that into consideration, and maybe that's worth studying?
These are all issues. Am I on mute? No? Okay. These are all issues that we have yet to address. We're kind of waiting for the decision on what the paraprofessional board is going to look like. We're trying to figure out the kind of training that these folks would need, both at the hearing level and at the appeal level. So these are all issues that we have considered, Carolyn. We just haven't had a chance to reach any consensus. And I just wanted to say, in response to Steve, we had a discipline subcommittee meeting on November 23rd, and Leah presented a bunch of statistics based on, I mean, we just have to kind of estimate, how many licensees are we going to have in the first year or two? How many complaints do we expect to roll in? How many will move beyond the complaint and investigation status? We have no real information on that. But based on the data that Leah was using, she came up with, if we were to use this panel model for hearings, it would cost about $210,000 a year. If instead of the panel model, we were to use the judges of the State Bar Court, it would come up to $571,000 a year. So that's like doubling or more. And so that's what we're kind of trying to avoid, at least at the beginning of this program. And I correct me if I'm wrong, Leah, I might have gotten those numbers completely wrong, but that's what I wrote down.
Yeah, I'm not looking at that cost.
Yeah, I know. It was hard for me to find.
But we were looking at like the per case, the breakdown of the per case cost of what goes through State Bar Court versus the, again, hypothetical cost of this model. I would say though, Julie, and then I see Ira has his hand up. I'm not sure we haven't explored Carolyn's question in particular about due process, because I do think we're fairly confident that a model that does not involve judges can satisfy the due process requirement. So I do think we've had the assistance of OGC and our Supreme Court liaison as well to the subcommittee. So my 2 cents on that. Did you want to call on anyone else, Justice Petru? Ira, maybe?
Yeah, on due process, I believe there's no doubt in the law that you don't have to use judges. Some of you may have seen the article that I sent around. It was from the Consumer Attorneys magazine. A couple of lawyers wrote something about let's look at the due process aspects of this. And I think they were quite wrong in their analysis. I mean, I've had to teach constitutional law. Had to is the word. And what due process requires, procedural due process, is a notice of the hearing, notice of the charges, I should say, and an opportunity to present your case to a neutral decision maker. And that's certainly the case here. That's provided, we've provided way more than that in appeals and all kinds of other things.
Okay. Did anyone else wish to chime in? I don't see anyone.
And do you want me to go on, Justice Petru? Okay. Then the next piece that we have also been discussing are public records and what should be basically listed on a licensee's profile on their web page. And then we're also talking in regards to what documents are public. we still have a lot of discussion, I think, around this, but we've made a lot of progress just thinking about what should and should not be public. Obviously, we believe anything basically from the notice of disciplinary charges up through the rest of the chart would be something that would need to be on the individual's webpage. We're looking right now, and that's kind of what made us kind of go veer a little bit in talking about the agreements in lieu of discipline and even the alternative discipline process. I think that's what ADP stands for. That process as well, and thinking about whether a lot of that should be public. So that's what we've been talking about lately. We also talked about the citation and fine, should those be public? We believe that those should be public, but for a shorter amount of time, looking at potentially 5 years for those on the website. And then I think that's kind of it on the public records on that part. There may be other things that we talk about for public records as, you know, malpractice actions and convictions and things like that. We have not gotten to that part yet. And then I know before we had also talked about the mandatory fee arbitration in the paraprofessional disciplinary system context. That's something that is our next step. We have not gotten there yet on that. And then also just more clarification on that compensation and training for those panel members. So I think that's everything that I have updated on, unless Julie, Ira, or Sharon has anything else to add. Oh, sorry, one more thing. And this is something that we would all, obviously, no matter what, we would have to do the standards of discipline. And that would be, for example, if you had a violation of X, this is the recommended penalty that an individual would get. So that would have to be something that would also have to be established for that process as well. And that's another thing we're going to be working on.
So was there anything further that anyone wanted to raise? I think this might be the secret to our success, which is schedule a 2-hour meeting in order to have a 90-minute meeting, and don't schedule a 90-minute meeting because then we're for sure going to run over. So unless, Leah, is there anything else we need to kind of circle the wagons on?
Nope.
You know what? I'm sorry. I have one more point, and I hope it's not going to be a long discussion if we are right out of time. But there is one on the regulation subcommittee. I just reviewed my notes, and there was one important piece that was left off. We do not have a recommendation on it, but we were hoping to get some feedback from the working group, and that's on fee limitations.
Oh.
And the basic note, and we can decide how much to talk about it now, is that we have not come to an agreement of whether there should be. Do you have that slide, Linda?
Yes, I'll
The
bring that
idea
up.
is, the purpose of creation of the paraprofessional program is to create a lower cost alternative to engaging a lawyer. Should there be any limitations or restrictions on the amount of fees? And when we had the last full working group meeting, the risk of excessive fees or overcharging was one of the main concerns about the purpose of regulation. And so we haven't been able to reach agreement. I think if we had some feedback, it could help. One possibility would be to have some kind of bright line fee limit or schedule. That would be controversial, I think. Hard to put together. Would we do it county by county or region by region? But is there some other way we could have regulation that would protect against excessive fees? So sorry, I didn't cover that.
No, not at all. I mean, and I'm just speaking off the top of my head, and it's not going to answer your question directly. But as I listened to you speak, it made me think about the slides you put up previously, the ones that I said, you really should, I really think we should have this in writing between the paraprofessional and the client, so that there is no question about what information is being transmitted, and that there can be a record of it. In some ways, to me, that seems like a much more powerful way to handle this rather than a fee limitation. If you make it very, very, very clear to people what the paraprofessionals can and cannot do, and that there are attorneys out there and also, potentially free legal services, that to me is the prompt for people to maybe go see what an attorney costs. I mean, it just feels to me that ensuring that people are aware of the limitations of what the paraprofessionals can do and of potential other resources is the most effective way of helping to ensure there's some disparate fee, right? Because you don't really want people charging the same thing unless they're doing the same work, rather than there being some kind of a bright line fee limit or fee schedule. But these are kind of unformed thoughts off the top of my head. So someone tell me I'm wrong. Sharon?
I am just wondering what other states are doing with fee caps, and if you know the answer to that.
We have not seen paraprofessionals in other states have fee limits. And quite frankly, I tried to look at other licensed professionals in California and did not find fee limitations. Now, again, I think there are some models. So when a court appoints a lawyer, there's fee schedules. When you take certain panel cases, when there's referral services, or if you're on certain panels, there's guidelines. There are restrictions. So there is a rule of professional conduct against unconscionable fees, and there's some description of that. So we could design some sort of a reasonableness standard, but we'd have to say what that is. And that's not easy, especially because if there's no bright line, the bright line's easiest to know and to enforce. If there's no bright line, it's a reasonableness, and maybe there's even some ability to encourage. So inform licensees of the purpose of the program and encourage it. But again, that's our rules of professional conduct are not set up like that. They're disciplinary rules.
It seems like everyone has their hands up. I just want to make a comment as a member of a committee before we call on folks. I also agree that giving people information about their choices may be a better option than having a fixed fee schedule. I especially like that in our informed consent, and I agree should be written, that they disclose any services that are available for free, such as local self-help centers, helping with domestic violence restraining orders, the agencies, because a lot of people do pay right now for services that are totally available for free, and had they known it's available for free, they would have taken advantage of them. I also want to mention that we are still working on this. We met just the other day, worked on issues such as contingency fees, advanced fees, and so on and so forth. So it is a work in progress. We would appreciate your comments.
Okay. Elizabeth?
Thank you. So for the first line right there, it says, given the purpose of the program is to provide a lower cost alternative. I think the most biggest purpose is the providing access to justice. And also it's about giving the consumer a choice. So between an attorney, and I think that the informed consent form does do that. And that sounds great. But also just to say it out right, I don't agree that there should be a cap on the fees charged by the paraprofessional. The main reason is because the market's going to regulate itself. The consumer is the self-represented individual that only has a certain amount of funds available to them. If the paraprofessional charges a lot of money, then the consumer will have a choice between an attorney, like the expensive paraprofessional, or a self-help center where they can get the services for free. So the market's going to regulate itself. If a paraprofessional charges attorney rates, the consumer will say, then I'm going to go to an attorney. Why would I pay the same price? I believe there's a good service by paraprofessionals that can be provided giving legal advice, but there shouldn't really be a cap. They sometimes do great work. We've heard other experts come in and talk about the level of service that paralegals, legal document assistants, immigration consultants do that maybe some attorneys are not able to give that same level of service. And then also just from a business perspective, we have to remember that these paraprofessionals are going to be running their own business. They don't rely on grants. There are some nonprofits, I believe, but there's different services for different people. But as far as the paraprofessional, we're expecting them to run their own self-sustaining businesses. And they will be relying on these fees. They do have business expenses. And I think this is a great way to create that access to justice without burdening, the judicial council's grants and not tapping into that. And we, these paraprofessionals are going to be helping people who don't have very much funds. And so I think, again, it's access to justice. Thank you.
Thank you. Erica, Judge Yu?
I agree that market forces are strong and people will be driven by cost and market forces, but I'm putting myself in the place of a client or even people who've been in my family. If someone doesn't speak English very well and they've gone to someone who is a paraprofessional who speaks the language that the client speaks, and then they're told, well, an attorney might cost this and you can go to the self-help center and stuff. I would think that the person might want to just stay with the person, the paraprofessional who speaks their language, or perhaps, in drug court, we don't have people who can really transport themselves very far. So they're going to go to wherever they can go in the neighborhood. So I don't know how onerous it would be, but in that contract, because I don't necessarily think there should be fee caps, but in the contract that the paraprofessional has with the client, I'm wondering if when they disclose, it would be too onerous for the paraprofessional to also disclose, well, if there's a language issue, well, these are alternatives for you of places you can look for a lawyer who speaks this language, or these are the alternatives in this geographical area. Because I think the market forces are strong, but there are other forces as well.
Thank you. Greg?
There we go. I just wanted to give a bit of a background on our regulation for attorneys in California. The ABA model rules for attorneys' fees does impose a reasonableness standard, and that's followed by a majority of jurisdictions. California long ago decided that they would not follow that majority trend for a couple of reasons. One, the California Supreme Court decided that they simply would not employ the disciplinary machinery from the state bar to police reasonableness of fees, because it found in most cases in which they were choosing to impose discipline on an attorney, there was elements of overreaching or fraud by the attorney. And so that's why we have as a disciplinary standard that attorneys can get in trouble if they charge an unconscionable fee. And under Rule 1.5, there's factors that are looked into. But that doesn't mean that we don't regulate the reasonableness of attorneys' fees. Attorneys are required to participate in mandatory fee arbitration if there is a dispute between a client and the attorney. And that, I think that's a very important element of the regulatory framework for attorneys that the group may want to consider here as well. The problem with, there are standards out there we could follow, because as I said, a majority of jurisdictions have adopted the ABA standard, so you can certainly do that. But then you're putting a strain on the disciplinary system to have all those cases come through. Right now, we get 16,000 complaints against attorneys each year. So you are putting a strain on the disciplinary system if you're going to ask the state bar court to start adjudicating the reasonableness of attorneys' fees and paraprofessional fees in this case, or whichever adjudicative body is policing the paraprofessionals.
Thank you. Julia?
Yeah, I just wanted to contribute the fact that there is some governance regarding fees of lawyers. If you look to the model in workers' compensation, they do have a fee limit as to what they would award. For a long, long time, it was 12%, which is why many work comp lawyers would have to take in a super large caseload to make money off those. Now they're up to about 15%, maybe even higher. But there are other statutory rules in that model, like 5710 fees for depositions and things like that. And I will note that all the settlements have to be approved by the Workers' Compensation Appeals Board. And in certain penalty situations, they can also give an award of attorney's fees. So I guess what I'm saying is there is one other model that you may want to look to in terms of attorney's fees being regulated in the California system. And it's in the labor code, it's pretty, I mean, most work comp attorneys are charging the exact same amount. And if there's a range, it is small. And then in local counties, my experience was that even when you're asking for 5710 fees for depositions, which is actually paid by the other side, which is the insurance company, counties like Stanislaus, San Joaquin, and things like that, they're low. It's not really a local rule, but they look to how many years of experience you have in order to say what hourly rate you can charge or should appropriately charge. So that's just the contribution I have about one other model that exists in California.
Thank you. Stephen?
Yeah, I'm in favor of fee caps. I think this goes fundamentally to the purpose of the program as presented on the slide. If the purpose of the program is to create a new class of professionals to compete with attorneys, that's fine. Let's not have fee caps. But if the purpose is to provide a low-cost alternative to lawyers, then there should be fee caps. I agree with everything Justice Petro said about the need to have everything in writing, everything spelled out. But by and large, the matters that we're considering for inclusion in the program don't lend themselves to a contingency fee arrangement. It's going to have to be billed on an hourly basis. And there's all sorts of potentials for misunderstandings as to how much is reasonable for an attorney to bill to draft an answer or respond to discovery or whatever it is. Having fee caps in place will protect the consumers and at the same time serve the purpose of the program, which is to provide a low-cost alternative. There are lots of examples in the law where there are limitations on what attorneys can charge. Workers' comp is one, MICRA for medical malpractice is another one. I sent a whole chapter in the Rudder Group book to Amos that has all sorts of other examples. This is not unprecedented. If we're trying to protect lower cost consumers, we should have fee caps. If we're trying to create competition with lawyers, let's not. I think our purpose is the low cost.
Carolyn?
Okay, so there's, I agree pretty much everything Julie said. I just wanted to add one thing, and the impact of those caps on workers' compensation is doubled by the way in which the law changed about 10 years ago under Governor Schwarzenegger, where massive reforms were passed. And so really workers' compensation attorneys are rare and harder to find, and they must have very, very large caseloads. And while there are very many fine workers' compensation lawyers out there, it does impact the practice. And it is a consideration that post hoc, there may be changes to the law that impact what we're doing. But I haven't really gotten a position. I'll have to think about this really hard about whether or not fee caps will help the public or not. Really good points have been made here about market versus non-market. But you can have changes in the law later that could have devastating impacts on what we're doing.
Was there anyone else? Anything further from the chairs of the committee?
No, sorry about the extra time, but that was helpful.
Thank you.
Okay, well then I'm going to call it a little early and wish everyone a good weekend, and at least for some folks, a long weekend. I know we have a lot of meetings coming up, and it's definitely pedal to the metal. There's no way to get this done between now and September without doing that. And so I really appreciate the fact that everyone has pitched in. I mean, it's a lot of laboring oars. It's not a couple of people carrying this. It's everyone really stepping up and moving things forward. And I appreciate that greatly. I'm certainly going to convey that. Next Thursday, I'll be doing an update to the State Bar Board of Trustees along with Leah's help. And I'm certainly going to convey how much hard work everyone has been doing. So thank you. And onward.
Bye, everybody.
Everybody.
Thank you.
Everyone.
Yeah.
Have a good weekend.